second day of our conference with a keynote. And we are very, very privileged to have Professor Simon Deakin delivering this keynote for us today. So Simon Deakin is a professor of law at the University of Cambridge, where he specializes in labor law, private law, company law, and EU law, and works at the intersection of law and economics, law and development, and empirical legal studies. He's the director of Cambridge's Center for Business Research and a fellow of Peterhouse College. After reading law at Cambridge, he completed a PhD in labor law under the joint supervision of Brian Napier and Frank Wilkinson, and joined the Cambridge Faculty of Law in 1990, following appointments at various other universities. And he has been a visiting scholar at several institutions, including Columbia University, European University Institute, and the University of Antwerp. Professor Deakin has delivered several major public lectures, including the ILO Social Politics lectures and the Tanner lectures, and is the editor-in-chief of the Industrial Law Journal. He is the author of many books and publications, has received numerous awards, including an honorary doctorate from the Catholic University of Louvain. So Simon, because your CV is so long, I decided that I would ask ChatGPT to summarize it. And what ChatGPT said is that you got an honorary doctorate from the KU Leuven, which is a sister university, but like with a very, let's say, strange relationship with the Catholic University of Louvain. So ChatGPT can mess up even the most, the smallest, but actually crucial details. Simon, we're super happy to have you. Thank you so very much. You have the floor.
Thank you very much, Valerio. Thank you for that very kind and, as it turned out, fascinating introduction. I haven't tried making ChatGPT do that myself, but maybe I should. Let me see if I can show my slides. Here we go. Okay. So hopefully everybody can see that. And okay. Hopefully you can also hear me okay. I'm
yes,
sorry.
We can.
Great. I'm sorry I can't be with you in Toronto. I hope that the conference has been going well. So I'm going to give a presentation on algorithmic management in history. And the reason I chose this theme was because I feel that algorithmic management is perhaps not completely new, and nor even is artificial intelligence. I know that it all seems wonderfully bright and shiny and really exciting and innovative and all these things. But actually, I think that there's nothing especially new about some of the practices associated with AI-related management. And even AI itself is not that new. And its roots as a practice and as a methodology are really quite old. So what I want to do in the talk is to trace some of the genealogy of AI back to its 18th and 19th century origins. And in the course of doing that, I will want to make the case that AI or computation and calculation have always been linked to understandings about the labor process right from the very beginning almost, and that computation in particular has from the beginning been used not so much to replace labor, but to assist in its routinization and its top-down management, and to promote work intensification, all of which has been highly problematic for workers. And AI today is very much in that tradition. So understanding that there is an origin to this, I think, helps us to understand also how one might respond to it and how labor law in particular and regulation more generally might be framed to respond to the current moment. I want to argue that there are many possible pathways for AI in general, and also for AI in the workplace to take, and that history might have some lessons for us in framing responses to the stresses and pressures which are being created by the advent of generative AI in particular, and predictive AI. And that very much affects the workplace, but it also affects the legal system. So if we think of the legal system as potentially standing between technology and workers and others affected by that technology, it becomes crucial to preserve a space for the legal system itself, which is free from some of the consequences of digitization and AI. And that's a huge issue for law schools and universities as well. I want to suggest that there are alternative pathways for computation and for statistics as a discipline and for data as a resource, which involve rendering public and transparent what is currently opaque about AI. So that's my outline. So when I say AI has a long history, I think we can trace part of this back to the rediscovery of binary arithmetic in the West. In the early 18th century, it's a phenomenon we associate with the Enlightenment. But the notion of reducing numbers to binaries was known, of course, in ancient civilizations in China thousands of years ago. But it was rediscovered by Leibniz and others in the early 18th century. So reducing numbers down to a simple binary, as Leibniz recognized, makes things possible which are not otherwise possible. So a miraculous new order appears. So many things can be organized if we use binary numbers, including virtually everything that we're now familiar with to do with digitization. So digitization, and hence the computer, AI, and everything else, turns upon this essential move, doesn't it? Right. So Leibniz understood that one could engage in a different type of mathematics and also in a different type of social organization as a consequence of binary coding. And one of the things he was very much concerned with was attempting to apply mathematical principles to law. So he may have been the first person in the modern era, anyway, to attempt to mathematize legal principles, legal rules, legal dogmas, put them into a binary form. Well, he was essentially using a kind of symbolic logic. We would say today he might have been doing symbolic AI as opposed to connectionist or statistical AI. And of course, in attempting to do this, he failed. Where people have been trying to apply mathematical principles to law for quite a long time before the current fashion for doing so. So, for example, in the early 20th century, it was quite popular to try to do this. And as recently as the 1960s, there was a major program in the Soviet Union for trying to introduce computation into the legal system. That also failed. And these historical examples also have lessons for us. But moving on from Leibniz, the next important moment, I think, in the development of AI is the invention of, well, kind of the invention of the computer, or something like it, by Babbage in the 1820s and 1830s. So Babbage's so-called difference machine or analytical engine is a forerunner of the computer in a number of ways. And Babbage was inspired by and also inspired many of the early machines of the Industrial Revolution. This is a picture of the Jacquard loom.
Simon, sorry if I interrupt you. I think your slides are not moving.
We discussed this before, didn't we, Valerio? Before I began my
Yeah,
presentation. Yeah,
but
it worked before. I don't know why it doesn't work
it
now.
worked before, yes.
It did work before. Yeah, yeah. Okay, so let me try a different tack. Is it you try duplicate? Is that better? Is it working now?
Are they moving? Yes.
Yeah.
Okay, now they are moving. Thank you, Simon.
Now they're moving. Yeah. Okay. Well, this is a modern
That's
technology.
my fault. Yes.
No, 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 no. It's not. It's my fault. I didn't press the right button on Zoom. Um, But anyway, I was showing this rather unexciting slide anyway. But here's a much more interesting one, which is the Jacquard loom. So the Jacquard loom, as you can see, and it's a machine from the 1820s, contains essentially punch cards as we would now know them. So it's not exactly an early computer. The Jacquard loom didn't, well, the design didn't differentiate between software and hardware, and nor did Babbage's analytical engine. But what we see with the loom is a kind of computational process. Certainly it's calculative. And we might want to ask ourselves, what's the knowledge contained in the coding here in the loom? The loom can produce at scale and very quickly what it would have taken artisans hundreds of hours to produce. So the loom has essentially captured knowledge which was previously in the hands of the guild, which was a producer cooperative. And by coding it literally in this form, it's of course taken that knowledge that was communal knowledge and placed it in the hands of the entrepreneur, of the early merchant capitalists who used these machines. The guild is effectively put out of business very quickly by the machine, because the machine can produce what the guild can produce, but on a massive scale, and much more efficiently. It can produce high quality goods. It's not just an industrial shift or a technological shift, it's a cognitive shift, because the knowledge that was the knowledge of the community of guild workers is now in the hands of the single merchant capitalist or a group of them. And the guild workers, of course, are effectively rendered redundant by this process. The guild kind of predates capitalism in a sense. The guild is a producer cooperative. In the pre-capitalist guild, the rules of the common law, for example, and then the rules of various cities and regions prevented non-apprenticed producers from entering the guild. So that's how the knowledge of the guild stayed within the guild. And to become a guild member, you had to serve an apprenticeship of normally 7 years. It seems extraordinary, but the whole point is that it's learning by doing. So you would learn your trade by observing and participating in the community of which you were part. And the relationship between the guild master, the journeyman, and the apprentice was absolutely not that of employer and employee or capitalist and wage earner. They were co-workers, and to be a master in the guild just signified seniority and skill rather than ownership of capital. For many, many decades in the 18th century, the English courts maintained the guild by enforcing the rules of the Statute of Artificers, but they stopped doing so over time through judicial interpretation, and eventually the guild rules were repealed in the 1810s. The end of the guild in France, where the Jacquard loom was first adopted, took place in the French Revolution, very, very swiftly as a result of legislative decrees of the convention. And the abolition of the guild is, in my view, a much more transformative moment than anything associated today with AI, because the abolition of the guild and the rise of the machine, the loom, which embeds computation, was essentially the transition from a late feudal, early modern economy, which wasn't based on a very clear capital-labor divide, a proto-industrial divide, into capitalism, where labor and capital are clearly separated. The guild is no longer a community. There's a very clear distinction between the workers and the employer. And the capitalist firm, the entity or the employer, through contract law and eventually intellectual property law, has ownership of the key knowledge needed to produce. That change is, in my view, more fundamental than the change we now associate with AI, because AI doesn't in any sense involve a return to a pre-guild structure, or for that matter to a post-capitalist one. It's an intensification of the top-down model, which the end of the guild triggered. Babbage himself was familiar with these debates, and he argued that the analytical engine he's invented would be an important tool for manufacturers, and he adopted Adam Smith's division of labor principle, But he took it a step further because Babbage recognized that once the tasks the worker performed were broken down minutely through what Smith called the division of labor inside the pin factory, this dehumanization, de-skilling process, which takes the multifarious skills of the artisan, separates them, breaks them down into simple routine tasks, and then gives them to different workers who can't combine them. This kind of dehumanizing process, which we call the division of labor inside the factory, the pin factory, which when Gordon Brown was British Prime Minister was put on the back of the £5 note somewhat miserably. Okay, this is what some people think capitalism always is, right? Just dehumanizing labor. Babbage recognized that with his analytical engine, this could be taken a step further. And so with the division of labor, when each producer is reduced to use of some simple tool, the union of all of them by one moving power constitutes a machine. And it was his analytical engine that would be the machine, although that didn't happen immediately, but it has happened over time and is increasingly now happening with AI. Interestingly, Ada Lovelace, in her commentary on the analytical engine, made a very interesting point about AI, well, as we would now call it, which we might come back to. She said the analytical engine has no pretensions whatever to originate anything. It can do whatever we know how to order it to perform. It can follow analysis, but it has no power of anticipating any analytical relations or truths. So in exactly the same way that modern AI is essentially a pattern replicating prediction machine that can't produce anything new and doesn't do anything itself, despite what people say. It can only be used by somebody who knows how to use it and for the purpose they want to use it for. It requires knowledge on the part of the user. In exactly the same way, the analytical engine Lovelace recognized would be a fantastically powerful tool, but wasn't conscious, wasn't intelligent, didn't create anything new. So with AI today, what AI is today, people knew in the 1840s, it seems, or Lovelace did. Now, Luddism, of course, was a response to the end of the Guild, which was entirely predictable because what replaced the Guild was initially really nothing when it came to worker protection. So physical resistance to a mode of production in which the old rules of what E.P. Thompson called the moral economy were dismantled along with the Guild was a predictable reaction. And this led to 20 or 30 years of violence and resistance in both France and Britain. During the Luddite uprising, if that's what it was, of the 1810s, the British state deployed more troops to counter its own citizens who were resisting the machine than they were deploying on the continent to fight Napoleon. So the state has always used force to speed up the adoption of technologies like the earlier looms and today's AI, maybe another harbinger. What eventually replaced the Guild was collective bargaining, and collective bargaining began to be established in England effectively from the 1830s and 1840s. And what also helped was the passage of the first Factory Acts, which set basic protections in respect of the working week and the length of the working day, and regulated labour conditions in factories through the course of the Victorian period. When the Factory Acts were introduced into Britain, employers argued that they wouldn't work, they would impose excessive costs. This is very much the same argument that we're going to get today. Anytime somebody suggests regulating AI, all the arguments about regulation are going to come back. But in fact, when the Factory Acts were introduced, eventually firms adapted to them and productivity rose as hours were reduced, and profits also rose in this period. But between 1810 and 1840 or so, wages mostly didn't rise, and productivity actually didn't increase much. Again, that's probably going to happen immediately with AI. It's not actually helping productivity, but it will push wages down most likely. If we come up to date a little bit, there's another part of the story about AI, which is very interesting. So when AI is called AI from the 1950s onwards, is very much associated with the work of Herbert Simon and also with Alan Turing, of course. And Herbert Simon didn't think of AI as somehow replicating the workings of the human brain, as is assumed today when we talk about neuronal models of AI, neurons and synapses, vectors and neurons used in deep learning models. Simon's model was the firm itself. So he thought that AI would be modeling a social process or an organizational process that took place within the modern bureaucratic corporation. And his early attempts to use symbolic logic to express AI were very much in that tradition. And Simon thought that this sort of symbolic AI, not today's connectionist AI, but the symbolic AI, would be a tool for modern management. Modern management would need sharp tools to assist managerial judgments. And in addition to operations research and linear programming, artificial intelligence would supply these. Meanwhile, Turing, in the course of developing his computational models, also addressed the question of what they could be used for. So in a paper in 1947, Turing predicts, first of all, that the machines he had been inventing during World War II at Bletchley Park would be used ultimately to replace skilled labor. First of all, the machine, those who use it, he said, will be divided into masters and servants. The masters would be the engineers doing the designing, the servants would be ones doing the actual coding and inputting information. But over time, Turing said, the calculator will take over the functions of both the masters and the servants. And so Turing, rather like Babbage, appears to have been not just aware that the machine could be used in this kind of managerial way to control labor and to de-skill it, but this was something which he actively advocated for, as far as we can tell. So this tradition of AI being used in a sense to consolidate managerial control absolutely isn't new. So when we look at today's factory, how similar is it to the assembly line of the 20th century? The Fordist so-called model, this is a Ford assembly line and an Amazon assembly line, if that's what it is, an Amazon warehouse from today, are surely not so far apart. Of course, there are many more people in the left-hand image. And we might assume that Amazon employs fewer people, perhaps, than Ford did, although that's not actually true. Amazon employs hundreds of thousands of people. And surely inside the algorithm-controlled warehouse, we see everything that was familiar from the way that the assembly line was organized inside the Fordist factory, top-down control, rigorous discipline, the machine dominating the workflow and in a sense controlling the worker. So new methods might have been found for this involving remote surveillance and instruction, but I would suggest that's a difference of degree, not of kind. When we think about whether the standard employment model can be applied to the Amazon warehouse, it doesn't seem to me to be much doubt that there's control and there's integration. There are all the things we labor lawyers associate with the employee model. And in fact, I don't see many people arguing that Amazon workers are not employees. But even in the case of Uber drivers and delivery drivers and ride-hailing app type workers, these are workers who don't have capital. These are workers who are surveilled. These are workers who are controlled. They are, many labor lawyers would say very clearly, employees or workers or subordinated labor. In fact, that's what most courts find today. Legislatures are a little bit different, but most courts tend to find, most of the time, that's the trend, that Uber drivers are workers or employees because they don't have capital and they are controlled. Actually, a generation ago, the taxi driver might not be controlled in the way they are now by the use of remote apps. Again, when we talk about whether my boss is an algorithm, lawyers are going to say, probably, well, sure, you can be remotely controlled and you may not see the human person who is your boss anymore. They may not be so obvious. But lawyers know that the entity which is the employer is the firm, and that your boss or supervisor may not necessarily be a particular individual, but you can still be an employee and you can be subject to managerial control. So with algorithmic management, again, many of the practices which are now being intensified were familiar from the 1990s and 2000s. Michael Burawoy's studies of labor process, or before him, Harry Braverman, of course, reported many of the same phenomena in the 1970s and then the 1990s. My colleague at Cambridge, Alex Wood, has written about this. Algorithmic management is not itself especially new and is associated very much with digitalization anyway, before we get to AI. So in all these respects, I think that there's a lot that's familiar about algorithmic management, familiar from the 19th century and also familiar from early parts of the 20th century. How should one respond to this? Now, alongside top-down work intensification, there has always been, it seems to me, a legal response. And initially that took the form of the Factory Acts. And the Factory Acts, as I said, were bitterly resisted by employers who argued they could not be profitable if the length of the working day was curtailed. The argument in favour of labour standards, which is that they discipline capital and require firms to accept, even at a very basic level, fundamental labour protections. And by doing so, they encourage investment in human resources. As we might now say, although we don't have to, human capital. Capital replacing labour is an issue, but very often when capital replaced labour and productivity increased, working conditions improved, hours were shortened. It's a mistake, in my opinion, to associate productivity with work intensification. It's just the opposite. Productivity is about the relationship between inputs and outputs, and getting more output per input is the opposite of requiring work intensification and dehumanization. And in fact, in the long history of labour law, productivity has increased over time as labour laws have got generally stricter over time. And there's a very clear international correlation between productivity and strictness of employment regulation. This was recognized by Marx in the 1860s, based upon the then factory inspectors' reports. Marx recognized that the Factory Acts were putting out of business those employers which couldn't adapt to a shorter working week. The chief objection repeatedly urged on behalf of each manufacturer is that they'll have to have a greater outlay of capital to carry on their business. But as regards labour in the so-called domestic industries or the intermediate forms, again, what we now call fishering was familiar to Marx. These firms that were unwilling to invest capital in their modes of production, well, so soon as limits are put to the working day and to the employment of children, those industries go to the wall. Unlimited exploitation of cheap labour power is the sole foundation of their power to compete. And so today, again, there will be those who say we can't afford to have labour protections because they put firms out of business. Well, yes, they do. They're going to put out of business the firms which are unwilling to adapt and are unwilling to progress. And that's always been the way. Now, when the Factory Acts came in, as I was saying earlier, the period between about 1810 and 1840 was a period of falling wages and stagnant productivity and social unrest in Britain. And the period from about 1840 to about 1914 was a period of rising wages, rising real wages for the most part, relative labour peace, relative labour stability, and also greater profitability and a high rate of return on capital for manufacturing firms. There are many factors behind this. At that stage, Britain had the benefit of imperial markets, which it largely controlled. But that's not the only basis for the success of British manufacturing in the 19th century. British manufacturing in the 19th century flourished on the basis of fairly effective labour standards. Britain was the first country in the world to have a Factory Act model, and one of the first to have nearly comprehensive collective bargaining. In the 20th century, productivity in Britain rose much faster, at about 3% per year, between about 1945 and 1980 than it has since the beginnings of the neoliberal period after 1980. So it's not the case that Britain was in need of a neoliberal revolution in the early 1980s. And in fact, productivity has seriously declined in the UK as there has been deindustrialization and the rise of a service economy, which so far hasn't been able to provide good jobs on the scale that the industrial economy did, and hasn't provided the spillover effects which enable public goods to be provided either. This is a context in which we need to think about regulation and capitalism and how they both work. Capitalism is not monolithic. Capitalism is varied. There are many different versions of it, even within the history of one country. What I think is also clear over time is that the legal and regulatory response to what I've been describing, computation, top-down control, work intensification, has not taken the form of rejecting technology, or of rejecting quantification, or of rejecting statistics. It did take the form of making statistics public. The art of statistics, statistics as a discipline, means the science of the state. And most 19th century states in Western Europe and North America went to great lengths to organize public statistics and publicly available data, to collect data systematically, to publicize that data, to make it available to everybody. So this is democratic statistics, and these democratic and public statistics then worked into social legislation, like here, workmen's compensation regulation in the UK in the early part of the 20th century. This public statistics formed an essential part of the construction of a welfare state based upon a universal wage earner model and universal social citizenship. Workmen's compensation, again, a very interesting episode in British history. The gradual acceptance of the principle of mandatory workers' compensation, no-fault compensation, regardless of the terms of the employment contract. You couldn't opt out of it, as you could with the common employment doctrine in the 19th century. You could opt out of workplace protection, but that stopped in the 1890s. It's no longer possible to opt out of social legislation, as it had been. There was a gradual improvement in provision for those suffering from workplace injuries and disease, and eventually a fall in the accident rate, although this took a very long time. It only really began to take place after World War II. But getting public statistics on accident rates, on compensation rates, was a critical part of this process. And this aspect of computation, the organization by the state of social protection, should also be part of the story when we think about computation, including AI. AI can be extremely useful to the state as a regulatory tool, but only if there's transparency. Transparency over which data are being used, where training data come from, transparency over which algorithms are being used. Also critically important, I think, will be to preserve some autonomous space for law in this process. At the moment, what we are contemplating is the automation of law, which in many respects will be a disaster. It will undermine the rule of law, seed confusion, distort the production of legal information, and again, centralize power in the hands of some large tech companies. The positivist legacy we all enjoy today really is the idea that law is whatever a democracy wants it to be in a modern democratic state. We've rejected natural law thinking that says law must be like this, okay? Either because of some higher law, a divine law, or some higher moral principle. Or today, we often hear law must be like this because of economic efficiency or because of law and economics or something like that. The idea of a free and independent legal science, law purified of these natural law taints, is a fundamental part of 20th century positivist thinking, expressed here by Hans Kelsen, significantly writing in 1934. I ventured to bring together some of the results of my earlier work on the problem of law in the hope that a younger generation will not abandon altogether the belief in a free and independent legal science. And the major threat to a free and independent legal science today comes from AI, and especially from legal tech. How best to move forward? So more concretely, I would suggest a number of things for labor law and labor lawyers to contemplate when thinking about AI. So firstly, I don't think AI, not being all that new, requires a fundamental revolution in labor law. It doesn't require us to give up the contract of employment as our fundamental point of reference, or collective bargaining or social insurance. It requires us to strengthen those mechanisms, strengthen health and safety law. As far as platform labor is concerned, normalizing platform labor seems to me to be a good strategy. Just as part-time work, temporary work, and fixed-term work were somehow normalized or brought closer to the standard employment contract in Europe in the early 1990s and in the 2000s through directives. So today with the Platform Work Directive, we see a normalization strategy, trying to expand the employee or worker concept as far as it can possibly go, but no further. Right, so the Platform Work Directive insists that employees and workers are platform workers benefiting from labor law, but doesn't attempt to apply digital law protections in the same way. The self-employed can benefit from digital law under the Platform Work Directive, but they don't benefit from labor law protections. And that seems to me to be the correct strategy. If we abandon the distinction between the employee and the self-employed, we're also abandoning labor law itself, because labor law has to have a boundary with commercial law somewhere. And if there were no boundary, it would not be possible to apply strong labor protections to employees or workers. So the platform work approach of separating the definition of the platform worker from the definition of the person performing platform work and enabling the latter to qualify for digital rights, but not for labor law rights, seems to me to be unavoidable, but also desirable if the employee concept can be widened using presumptions and other means. Again, I would stress the need to maintain the boundary between labor law and digital law. Merging them or confusing them will weaken labor law for sure. Digital law doesn't give workers the protections they need. For example, most digital protections can be waived or are subject to the consent principle. Digital law mostly operates as a default rule. In return for consent, consumers or data subjects or workers, as the case may be, acquire certain rights. I know there's a debate about whether employees can waive their rights in a digital context, but Article 22 of the GDPR fairly clearly says they do, and they need to in order to qualify for the limited right to an explanation, for example, that Article 22 might provide. Digital law is where tort law or labor law were in the 19th century. In the 19th century, you could contract out of the right to protection in return for a job. And the default rule approach of digital law is a very long way away from the floor of rights approach in labor law, where you cannot contract out of most labor rights. This is a fundamental point of difference, which we, in my view, need to maintain. We're told that transparency with AI is very difficult to achieve and that AI is fundamentally opaque and that even those who make AI apps don't understand how they work. I think all this is nonsense. The people who are making AI applications know perfectly well how they work. They perfectly well know what machine learning is. And if they didn't, they wouldn't be able to make these things work. The opacity comes from the unwillingness or inability of large tech suppliers to publicize what's in their training data or to publicize the methods they use. There's a wall of commercial secrecy which comes down, understandably, because these are proprietary trade secrets very often. But their unwillingness to disclose what's in training data makes the use of that training data in algorithms extremely hazardous for any entity using it. And because of the way supply chains are worked, very often employers or public entities won't know where the training data have come from. In the particular AI, they might be being supplied with by a cloud supplier like Amazon, for example. The reason we don't have transparency over training data is not because it can't be arranged, it's because it's not in the interest of tech providers to provide it. But in the 19th century and the 20th century, ways were found to require disclosure by producers of fundamentally dangerous products. And AI is a fundamentally hazardous or dangerous product. And it will have to be disclosure at some point if major harms are to be avoided. And we already know what some of those harms are, including harms to democracy and the rule of law. So finally, I would suggest that we can't do much either unless we address what's pushing AI right now, which is not its inherent benefits, because it probably won't improve productivity. And often AI being probabilistic will be in error and will cause distortions. There will be many negative externalities from the use of legal AI. But this is being pushed not because AI is fundamentally useful to the people who might use it. It's because of venture capital flowing in at a huge scale and pushing its use. And so I think we should address this too. Venture capital is almost entirely dependent in practice on two things. One is a spillover from state-led research and innovation, and secondly is tax breaks. I recently concluded research on venture capital in the UK, and one of the things I was told very clearly by venture capital funds was they couldn't operate without the tax breaks that states give them. So I think we also need to address that question at its roots. Okay, so I'll conclude with that. I think that fundamentally we can regulate and govern AI, but of course this depends upon correctly understanding its nature and correctly understanding what can be done to control it. Thank you.
Thank you, Simon. Thanks a lot. Thank you so very much. It was a extremely fascinating lecture. We were really lucky. So I have prepared some remarks as a discussion, but actually your presentation has also prompted I think it will be good for me to, before my discussion, asking a couple of questions to you, if you can answer, because if we depart a little bit from the question of AI, but it's something that is related to AI. Now we are now again on the brink of seeing many policy institutions internationally advocating for the deregulation of labor law because of AI. I mean, every decade there's a new excuse, right? So it was the financial crisis 10 years ago, and now it's AI. And actually, when this happens, what we see is that there are all these sort of very flawed indicators that come about to say that the labor laws are too rigid, and therefore we should dismantle them. And we also have Janine Berg here in the room, and you and Janine and many others have debunked many of those methods. I was wondering whether you could say something around the idea that we need to dismantle labor laws to promote economic growth, because I know that you have spent a considerable amount of time debunking this, and I think this message is going to be quite important in the next few years.
Yes, of course. I didn't address that in the talk today because there's so much to say about AI. We have recently conducted a review for the British government in connection with the adoption of the Employment Rights Act in this country. And to do that, we drew upon earlier evidence, our own earlier studies, and the state of the art in this field. So there's a summary of this in the report we wrote and was published a week ago on the Employment Rights Act. And also the British government, the Department of Business and Trade, published an impact assessment. And the impact assessment uses our own report, which predicts a small increase in employment as a result of the adoption of slightly stricter labour laws in the UK. The UK is still not very strict in terms of OECD benchmarking, but the adoption of the Employment Rights Act will, I think, take the UK above Canada in terms of the overall level of strictness according to our index, and above the USA and above Australia, but it's still behind Costa Rica. Costa Rica has stronger labour laws than all the countries I've just mentioned. And these are the countries at the bottom of the list for the OECD. So our own studies show that in the UK over the past 50 years, stronger labour laws have not been associated with higher unemployment, but with higher employment. And for the OECD as a whole, we find that laws on 0 hours contracts, laws on leave rights, and stronger trade union rights of the sorts contained in the Employment Rights Act, which are all new to the UK, new rights are being adopted. In the OECD 37, the other OECD countries, those laws are correlated with productivity and employment improvements. And stronger trade union laws are associated with a larger share for wages and salaries in national income. Of course, because labour laws redistribute from capital to labour, they're bound to be resisted by certain elements within capital. And some employers, as Mark said, will go to the wall when stricter labour laws are adopted. And it may be that the rate of return on venture capital investments is less than it would otherwise be. So, of course, there are always people who will oppose labour laws. The question for any social scientist looking into this is, what are the aggregate effects? What's the effect on the economy as a whole? Does the economy grow when we deregulate? Apparently not. Now, you may say it's all different with AI. And of course, we don't know yet because our own study is a backward looking one when there wasn't AI. So AI makes it different. But let's bear in mind the assessment of, for example, Darren Asimoglu and Simon Johnson. Okay, so their assessment is senior economists that AI will probably contribute relatively little to productivity improvements for various reasons. Okay, and deregulation will probably also not contribute positively to productivity. Right. Now, there are some countries and there are some contexts where deregulating might increase employment, but only at the expense of more precarious work and low-paid work. Even that's not clear. It differs by country. Even for the UK, with a liberal market economy, we don't see employment being reduced by the adoption of stronger labour laws. So you refer to indices and benchmarks being cited. state of the art in the social science literature, as recent meta-analyses have shown, is that the apparent OECD World Bank consensus of the 1990s is no longer the consensus in the social science community. And our own index, people using our index, and to some degree the OECD index too, the recent studies mostly show improvements in productivity and also innovation flowing from stricter labor standards, including the study by Virul Acharya and his colleagues for Silicon Valley, admittedly before AI in the 1990s. Slight modulations in California's employment at will rule led to more patents being registered, more people employed in smaller firms, and even more small firm high-tech startups. And they explained that by reference to the use of slightly stricter employment protection standards in encouraging knowledge sharing between workers and employers, which is critical for innovation.
Thank you so much, Simon. So I will try to be as brief as possible with my discussion, then I will leave you some time to react, and then I will open the floor to questions from the room and from online. Now, one of the things among the many things that your slides have prompted me to think is the question of the binary coding as it applies to jobs. Most algorithmic management systems function on the basis of these binary codes. And the problem is that when you try to apply these codes to jobs, they almost invariably fail. These systems of algorithmic management, of supervision, of surveillance are extremely flawed because they start from the assumption that a job is a simple thing that can be described in coding. Our jobs, and Janine was also mentioning yesterday, jobs are much more complex bundle of tasks that everyone who was done collective bargaining know that to define a job in a collective agreement, you in many cases require pages. And even that leaves outside so many things that are present in a job. So when we try to manage people through codes, we leave fundamental parts of their activity out, without which the company cannot run or the organization cannot run. There's an example that I like to bring up of a couple of years ago. An hospital in the United States introduced this system of supervision that basically docked the pay of doctors anytime they were not at their computers. So anytime a doctor was in the talking with a patient, the computer thought that the doctor was inactive, so that the pay was docked. In most of the cases, the systems that are now marketed are not bespoken to the reality in which they are applied. And AI, as of now, is a very narrow operation. It can only do certain things, some of them well, some of them not good, not well. When you try to apply this narrow AI to a much more complex reality, which are our workplaces, and you want to use HR software that you bought off the shelf for a completely different industry maybe, and you apply a software that was conceived for the banking industry to a factory, of course you're doomed to fail. So we are seeing many reports and now and many studies that show that some of the algorithmic management systems that are now flooding our labor markets drive down productivity because employees have to now reverse engineer the system, try to understand what the system likes in order not to be disciplined, and they waste a ton of time just to try to game the system. Which of course is going to drive down productivity. I wonder whether you had some reflections about that.
Yes, I think that's right. So even supposedly de-skilled jobs always require tacit knowledge. I mean, it's almost impossible to eliminate this, although people try. So the more you can routinize a task, the easier it is then to automate. So routinize first, then try to automate appears to be the strategy behind the growing use of AI, as Babbage himself was doing in the 1840s, or recommending people did. So the more routinized a task is, the more mechanical, the less discretion we give employees, in principle, the more straightforward it is to automate, but the end product won't be very good. Often, though, the people suffering from the lack of quality of the end product will be consumers or users, not necessarily even their employers, and not the cloud data suppliers. So there are some entities in the supply chain who will clearly benefit from this process. Cloud suppliers, data suppliers, maybe some firms. Some firms are monopolies or near so in the public sector. Okay, but the workers will suffer and the consumers will also suffer. They'll receive an inferior product. That's what I mean by a negative externality coming out of this process. So it's therefore essential to require employers and their suppliers to be more transparent about what's in training data, but it will be an uphill battle because at the moment the whole market is premised on what's in the training data never being revealed. But of course, if the training data are generic in nature in some way, or maybe sector specific, and they're then applied out of sector, they won't work. But even with a scenario where you're perpetually surveilling, this may happen soon, you're perpetually surveilling a workplace and collecting data about the workers who work there, and the data can come from them being filmed, can be transferred into a digital form in some way. Perpetual monitoring, perpetual surveillance. Okay, so then you might say, well, at least the data are accurate. Okay, even there, you have the problem AI always has of not dealing with the new case, the zero-shot case, not dealing with a new situation. AI is not modeled on the human brain, is not modeled on human language. It replicates features of human language, but it's not human language and it's not human learning. Okay, I think we need to bear all this in mind. It's kind of a pale shadow of all these things. So even learning in a controlled environment is going to be very difficult to achieve. And then, as you say, you've got the costs of retrofitting it or trying to work out what to do when it goes wrong or trying to avoid using it or working around it. I'm sure that's going to happen a lot in law firms. We already hear anecdotally of law firms trying not to use the legal assistant their firm has paid a lot of money for, partly because no one's going to learn anything in the firm if they do, including the young trainees, new staff. So we already see the negative consequences of the rush to adopt AI. The losers in the short term are going to be workers and consumers. Hopefully, eventually it'll be possible to attack this at source and to require transparency in the training data, I think.
Thank you. Thank you. So we now open the floor to questions. I have a question from online. And of course, people in the room are more than welcome to raise questions to Professor Riglin. So I'm reading this question that I got online. Could Professor Deakin expand on why he thinks AI will not make service work more productive along the distinction of task augmentation and task replacement? Introduction of AI agents, etc. Or are such agents more of the same, new forms of control domination?
Well, we just discussed it in a sense, haven't we? So there are many problems with adopting AI. There have been studies already of how HR professionals either use it or get around it, and we'll soon start to see systematic studies of how law firms are using it. At the moment, I can only really go on what I hear on the grapevine, but maybe other people here today, have heard some of the problems already which law firms are facing. The Acemoglu-Johnson interpretation, I think, goes back to an understanding of the limits of AI. So we have to go right back to basics. What does it do? It's not intelligent. It doesn't learn. It's a kind of pattern matching, a bit like a superscale of autocomplete. Right. Okay. So that's what it does. It's impressive in many ways. But predictive AI, which is what we're really talking about here, predictive AI, not generative AI, predictive AI, predicting what people will do and mimicking that and using that as a basis to automate either processes or decisions. Predictive AI, according to some experts in the field, is just not very good. Okay, so you see this in the AI as normal technology website, for example, Narayanan and Kapoor's analysis. Many studies show that predictive AI works 50% of the time. Now, you may think it's amazing it can work 50% of the time, but as they point out, that's just a random result. That's equivalent to tossing a coin. It's no better than that. So the reason predictive AI doesn't work is what we've just been discussing. It's very hard to model human interactions with other humans and with machines. It's just very difficult to model this. Symbolic AI never succeeded. Now, generative AI, despite what Valerio said earlier, is probably better than that much of the time. But the problem there comes from the fact that it is so good and can be widely used, but is never perfect. You have to really know how to prompt ChatGPT, I think, to avoid getting poor results. It will give you different results to the same prompt because it's probabilistic. It will make the kind of obvious errors Valerio was, or not so obvious ones Valerio was talking about before. The danger there is it's too good in a sense, but not completely correct and not as good as things people can do, but a whole lot cheaper if you don't need to employ them. Now, if productivity just means producing the same output for less input, that's possible. You might employ fewer people, but there'll be probably a deterioration in the quality of the output. Okay, so I'm not saying it always leads to lower productivity, but I'm happy here to rely upon, okay, people who are more expert than me in computer science, Kapoor and Narayanan, people who are more expert than I am in economics, Asimoglu and Johnson. I think these are important critiques of AI, let's put it that way.
Thank you, Simon. We have now some questions from here in the room. Please, if you can tell your name and answer the question.
Thanks. John Weir, Canadian Association of Professional Employees. I really enjoyed this presentation. In a past or other life, I am a labor historian, so this really spoke to me. But one of the things I was sort of hoping you talk a little bit more about is the way that the tech industry presents AI as something, totally new and transformative. And one of the things, or the context I really appreciated you sort of providing, is that, well, this is just a new form of algorithmic management, which has existed now for 200 or 300 years. And I was wondering then too, if you could talk about the strategies people in the past have used to push back against algorithmic management and how those kinds of strategies could also be adapted to the push against this newer and more all-encompassing form of algorithmic management.
Yes, of course. I think firstly, it's not surprising that we are told that this is a wonderful shiny new thing, because that's what always happens when there's a big technological change of this sort. And no doubt people felt the same about the Jacquard loom. In a sense, it was a miracle, and it was very interesting and fascinating. And the same goes for all the subsequent innovations that we're familiar with from the assembly line up to today. There's a tendency to present something as new and to overlook the continuities. Today, that's exaggerated by the need to get funding for what's called innovation. Okay, whether or not it's disruptive. So the pitch that has to be made to investors is this will be completely new, transformative, and disruptive. That's an advantage for investors, it seems. So partly it's just rhetoric, and of course, if one only has to read, The Guardian or whatever, the Times every day to see something new and exciting about AI being reported. Emily Bender and her colleagues refer to this. I won't say what they call it. It's not a very nice description. Nonsense mountain, right? It's nonsense mountain that we're on. We're getting so much nonsense being thrown at us by AI. As they say, it's very difficult to resist it. It's difficult to counter it. Difficult to point out that it's not what it means. And partly because, again, defenders or advocates of AI will simply say, it will be better next month, or it'll be better next year, or it will get better. It's a kind of naive teleology about any kind of evolution. Or I often see from fellow academics, it has learned to do these things. Right? Okay. AI does nothing on its own. AI is a tool, isn't it, used by people to do things. Right? So it's really important not to anthropomorphize AI. We should try not to refer to them as AI agents. When they call a legal assistant that, or an AI agent, when they call it that, they're endowing it with powers it doesn't have or couldn't possibly have. Okay. Although I admit, okay, as a so-called skeptic on AI, we struggle to get a voice. Right. Okay. Now, what has happened in the past? Things we are familiar with. A combination of self-organization and public regulation has always been the way that labor law works. Today, there will be those who are on the front line resisting AI, is difficult in the Anglo-American or common law world, isn't it? Because we don't have works councils. We often don't have unions in the workplace in the way that we used to, although we do largely in the public sector, that's true. But in the German or mainland European context, where in nearly every country there's a works council or enterprise committee with powers to mediate the introduction of new technology. And that's what happened in the 80s and 90s with digitalization in Germany. It was very much mediated by the works councils. So we need to press for universal workplace recognition or works council representation as a fundamental social right. It's almost more important than anything. We need to mobilize the case for public and open democratic statistics. We need to make that case very clear. This is not rejecting mathematics, not rejecting statistics. But I also feel that those of us who are prepared to make the case for an economic argument for labour law, we say labour law has these economic effects, that case has to be made, and it shouldn't go by default. Within the labour law community, the sorts of arguments I've been making about how labour law works in the economy are very controversial, because many people would say this is not the best way to defend labour rights in terms of their economic effects. I'm going to go on making the case for how labour law works as a matter of social science and description. Okay, so we recognize some problems with AI. The way to solve those problems is to invest in our own knowledge base and to understand how it works and to do social science research as best we can to get the work out there. And sometimes governments are receptive. We're in a moment right now where the UK government happens to be receptive to that sort of analysis. It hasn't been for most of my career. These events come along once every 20 or 30 years. Okay, so as a social scientist or lawyer, you might get the chance to intervene in these debates. But I suspect the way we deal with this is the way we've dealt with it in the past. Again, I don't think we need a fundamental transformation in our tools or concepts. There's no point waiting for that. What we have is usable in many contexts. And it will evolve. It took 20 or 30 years to get the first Factory Acts adopted after the factory came in. But actually, within the space of 5 years or so, or even less with the introduction of AI, we've seen the Platform Work Directive, or in its new form, the Platform Work Directive, and many, many countries around the world are following the Platform Work Directive. South America, Mexico as well, Middle America, okay, Mesoamerica, South America, some African countries, East Asian countries adopting the Platform Work Directive model. That's Canada too. Yeah, very helpful.
Thank you. Thanks a lot. We have another question from the audience here.
Hi, Graham Cox. I'm a researcher at Unifor in various sectors, including energy and transport. I really enjoyed your presentation, Simon. It's great to hear some classical theory sort of inserted into this dialogue. It's especially important, I think, for a labor audience because we deal with that intersection between capital and labor and the tensions and the struggle there. Part of the background for this conference, I think, is that we've learned, what we've learned through this conference is that AI is not necessarily new and it's not driving a brand new or revolutionary sort of process. And I think you outline that very brilliantly in the history there. In terms of some of the things that you brought up, and I had a question around sort of regulation. So bear with me here in a second, because I'm not a lawyer, so the legal stuff is beyond me. But the economics of that discussion around productivity, and we hear a lot about productivity in Canada and especially the UK and the metrics that they use, and that's very, if you want a neoclassical view of productivity. And if you look at the classical view and looking for partners, you were saying looking for partners in the economics realm, it's very difficult these days to do that. The productivity in a workplace, if AI is similar to other automation programs in history, it comes from that labor struggle and the fact that we have some pushback on the shop floor. So if you looked at a machine shop or a factory, the implementation of some automation on one part of the line can only really lead to a productivity increase instead of speed up if the workers refuse to be sped up by that increased productivity in part of that process. And I think AI is very similar to this. It just applied to a different kind of factory, a different kind of production process of thought and knowledge generation and writing. And so it's not surprising to me when you report that actually countries that have higher and stricter regulation and better labor laws that protect workers pushing back against these sorts of implementations by management to not actually get productivity gains, which is an increase in output for the same input, but actually just increase the speed of the line and use this new technology and the mythology around that new technology to try to drive speed up. And we can get into the economics of how that is financed too, but it's down to the shop floor for the union. Part of the way that we actually push back against this is to take a critical view of that productivity gain that's being sought. Translating that into something above the collective agreement, into regulation and into law, seems like there's a bunch of areas to attack on that. Regulation through legislation, obviously, but it's also regulating the way that the manager, as you're saying, through algorithmic management, is being augmented by this tool, and that way that tool is being implemented to try to drive speed up and try to suppress wages and to get more out of the workers that are left in the shop and haven't been replaced, but have been augmented essentially in that process. So I was just wondering, for our labor folks and myself who are not lawyers, what do you suppose we would need on the economic front to explain this to our MPs or here in Canada or local politicians who are taken in by some of the mythology around AI and don't understand that sort of productivity is actually a process by which society needs to decide where that increased in growth and output and in the end the competitive aspect of that, because we do exist in a global competitive field here, especially most of our firms that we work for, that will actually help drive that real productivity and real output agenda. So that was my question. But thanks very much.
No, thank you. I think it's first of all important to say that it's not an argument against progress. Okay, there may be aspects of AI which make it a very hazardous product, but in the same way that anything else industrial, like chemical products, are inherently dangerous if they're not regulated. Today we regulate all those things, right? So we have standards for product safety. It's not difficult to make that argument in some contexts, maybe more often consumer protection than employee protection. But states have a strong interest in minimizing the hazardous consequences of any new technology. So there will be people who are receptive to the argument that it should be regulated. In terms of the discussion about the economic effects of labor laws, it is of course possible to argue that the United States, because it has weak labor laws, therefore has a high level of innovation. If we had longer, we could discuss the United States, but it's not the only player. There are many parts of the world where labor laws are significantly stronger than they are in the US, or for that matter in Canada. There are also different approaches to AI, especially in East Asia. So the East Asian systems, I include China and Korea and Japan. Some are democracies, some are not. Okay, but they've all had a different approach to economic planning and a different approach to labor law and a different approach to productivity to the approach in the UK and the US in particular. They've avoided deindustrialization, and in China's case, they've rapidly industrialized. It is not the case that labor laws are weak in Japan, Korea, or for that matter, China. In fact, all those countries, they've recently been strengthened, and historically, they have an improving productivity rate, whereas the UK has low productivity. The US may be a different case. We should drill down in the data. We could discuss the US if we had more time. Our own data suggests that actually strengthening labor law in the US has historically led to productivity improvements, but not always to employment gains. So we really need a situation where productivity leads to higher employment. So there are other things we need apart from labor law. We need investment in training and in public infrastructure. So very much a mainland European, or for that matter, East Asian model. That might be attractive if it didn't come with stereotypical assumptions and beliefs people have about the way economies work. And I still hear people say China's rise is down to cheap labor and undercutting the West. That is not the case, in my opinion. And I don't even think it's true that the China effect is what caused American deindustrialization. That deindustrialization was beginning before China entered the WTO in the 1980s and 1990s as a consequence of a very weak labor law system. And already then the financialized economy and shareholder value taking over from a stakeholder approach. So I think it's unhistorical to blame globalization for American deindustrialization. So obviously there are lots of complex issues here. And some policymakers are more receptive to being convinced of these arguments. I'm not saying it's easy to make these arguments. They have to be made over and again. As Valerio said, the case for deregulation comes back every decade or so in a new form.
Thank you so much, Simon. I think I'm gonna abuse of my chair prerogatives to ask the final question for this discussion, and it goes back to what you were saying about, if you want, the structure of the laws and the need not to abandon labor law to face the technological changes that we see in workplaces. In many cases, we see that the answer that is proposed to the rise of algorithmic management at the workplace has a lot to do with privacy. And there's people who say that we can just rely on privacy laws to deal with algorithmic management at the workplace. But as a matter of fact, algorithmic management doesn't only impact on privacy. It has impacts on discrimination, because algorithms can discriminate at the stage of hiring, but also at the stage of managing the workforce, and also in the stages of promotion, termination, retention. But also it has huge implication on occupational health and safety. If you are followed all the time by machines that tracks your every movement, of course you're going to develop psychosocial risk, stress that can have impact on your occupational health and safety. And I would say also that the other thing that privacy laws cannot do is to take care of the fact that in many cases these machines actually are used by employers to decide on working time, on pay, on work pays. And these are all items of collective bargaining. So effectively, if we only rely on privacy, what we're going to do, and if we only rely on just information, like the employer has to inform you that they are using this system, then this is a kind of laws that is quite popular here in Canada. There's several initiatives that say, well, the employer will have to tell you that they're going to use these things. And as a European, of course, I say, well, that's not nearly enough. There is a risk of hollowing out of collective bargaining if we don't tackle the idea that these machines don't only affect personal data. I was wondering if you had any thought around that.
Yes, no, thank you, Valerio. Okay, so as a labor lawyer, you might expect me to be a bit skeptical of the idea that data protection law or privacy law can do this, but that is my position, and that's because, as I said, data protection law appears to me to be at the stage that labor law was over 100 years ago, when you could contract out of social protection or health and safety, the employment at will rule, the fellow servant rule. Most data protection law is, as I said, a default rule rather than a mandatory binding rule. We might discuss how far employees can consent for the purposes of data protection law. But I would continue to suggest that data protection law is 150 years or so behind labor law in this respect. Sorry, data protection lawyers. Okay, so basically, labor law, you can't contract out of most of it, and labor law requires reasons to be given. Unfair dismissal law requires the employer to give a reason for the dismissal. Works councils are entitled to explanations for what employers are doing. Working backwards from dismissal, if the employer must find a reason for the dismissal, they must also normally find a reason for disciplinary action. Under the unfair dismissal laws of virtually every European system, and no doubt many more as well, the US doesn't have unfair dismissal law. Okay, well, that's thanks to policy decisions and indeed academic research on the employment at will model from the Chicago School in the 1980s, very influential, pushing back against the idea that employers have to justify what they do to employees. Labour law exists at a point where it can provide some countervailing power against capital. That's its whole purpose. I agree with you that data protection law doesn't have quite the same approach. It's not necessarily harmful, but it's orthogonal to what labour law does. There's a big debate about whether there's a requirement to explain a decision taken, I say taken, by an algorithm, assisted by an algorithm, but labour law already imposes that obligation to explain on the employer, and it's the employer which takes the decision. People say, oh, well, the algorithm is doing it, not a particular person, but labour lawyers know that the employer isn't a human being either. It's a corporate entity. And we have techniques to identify the entity in question. So I'm not against combining or rendering complementary labour law and digital law. My point is, don't confuse the two. So I think the Platform Work Directive had the right approach to this, and is actually a good model in how to proceed.
Thank you very much. So I think this concludes this session. Thank you so much, Simon. This was a fantastic discussion. Thank you for your time.
Thank you.
Thank you very much. We will now have a short break of 15 minutes and we'll reconvene at 11 here in the same room. Thanks again, Simon.
Thanks very much.
Okay. Thank you very much for being back in the room. We have the last panel of this conference. And actually, this is, if you want, the culminating panel of the conference. And we have really a wonderful set of panelists here. I am very, very excited to welcome them. Starting from my immediate left, I have Henry Eckenberg. He serves as the Chief Experience Officer of CHRO Association and the CEO of HR Policy Global. And that's the Chief Experience Officer. Henry oversees the business, financial operation, and strategic priorities of the association. Harry received his JD from Penn State Law in 2010 and as an LLM in Securities and Financial Regulation from Georgetown University Law Center. Mr. Eckenberg has also an Operation Management degrees from Virginia Tech. Thank you for being with us. And then we have in the middle Professor Sarah Slin. Professor Slin is a full-term faculty at Osgoode Law School and is also a labor arbitrator. She is the co-editor of the Comparative Labor Law and Policy Journal, holds a PhD in industrial relations from the University of Toronto and a LLB from the University of British Columbia, among many other degrees that
she's an overachiever is what we call that.
Exactly. On my extreme left, I have Lara Payne, who has served as Unifor National President since 2022. After senior roles as Atlantic Regional Director, Unifor, first woman National Secretary, Treasurer, and President of the Newfoundland and Labrador Federation on Labor. A feminist and labor activist since joining the CAW in 1991, she is the first woman elected to lead Unifor. So we really have a parterre de roi, and it's fantastic. And we are very, very lucky to have this panel to culminate this conference. And I want to allow them to have as much room as they need for their remarks. So I'm gonna limit myself to a couple of questions, and then we'll open the floor for questions from the audience. So the first question that I would like to pose the panel, and then I will leave them 5 to 10 minutes each to present, is what are the main trends that they see in the field of AI and work, both talking about automation of jobs, but also automated surveillance and algorithmic management, and what are the main challenges and opportunities that they see raising from this phenomena. And I will start with Henry and we'll proceed.
Thank you. I think to start, it might be helpful if I talk a little bit about the CHRO Association, who we represent and what we do as an organization. So the CHRO Association is a Washington, D.C. based trade association or employers group. We represent the Chief Human Resource Officer, so the highest ranking HR official of major US and multinational employers. So we cover a lot of things for them. We do public policy and advocacy work in the US with the US government, which, let me tell you, that's an adventure these days. The conversation could get dark here, but I'll move on. But we also do a lot of practice work with them about what the CHRO specifically is facing, peer networking, surveys to try and help our members connect with each other and understand kind of uniformly what the challenges are that they're facing. I'm really appreciative to this invite. I'm the executor of an estate that has just turned into a nightmare. And when I told my wife yesterday I was headed to the airport, she was like, "Are you going to come back?" And I said, "No, I think that the estate issue is the final straw, and I might just stay in Canada. But alas, I have a 2:30 flight. So now I'll get on topic. So what are the trends and what are the things that CHROs are talking about? Obviously, you would really have to be living under a rock to not have AI be kind of a front and center thing in the workplace. And the CHROs are no different. So it's kind of progressed a little bit of like, what are we going to do with this? And trying to figure out our members for each of their individual business, because like we heard earlier, there's not uniformity that can be applied. So it's kind of progressed a little bit beyond, or it's progressed beyond like, what are we going to do? There's kind of a why established now. Now, the why is difficult because AI as a product is changing so quickly, but there's an idea and a strategy, and now CHROs are working kind of on the how. Now, we work with CHROs specifically with workplace AI and focusing on the HR side. So we don't have any like expertise or resources on like automating factories or things, but it's the kind of strategic decisions and how the company is going to adopt and look at AI. And the two biggest issues and trends are, and we took a survey of 75 of our CHROs in November, it is adoption, having employees adopt the tools that they're being provided, but more like right there, and more importantly, is the need for training, reskilling, and upskilling. Because our CHROs recognize, and we heard in the last panel, a lot of the problems with AI. What I use as an example are the prompts from ChatGPT. If you're looking for a nice restaurant in Toronto, what you tell it, it's going to give you an answer, but maybe that's not the greatest answer, you know, and if you ask it the same thing twice, it may give you two different answers. So the same problem is what the CHROs are working to train and skill, make sure their employees have the skill and know-how to use the tools. And that is really the most front and center thing right now for them. Now, they're also finding data privacy and security risks, particularly for professional services firms. The data privacy of client information going into an AI model, and then the, you know, managing what the responses are and how the employees use that is an issue. So, you know, in the end, the CHRO is the talent leader of the organization. And the big issue is making sure that the talent understands how to use this tool. What are the kind of constraints and guidelines that need to be, you know, like where's the human thought and critical thinking, and making sure everybody understands that. it's a really high priority. So half of our survey respondents said it's the highest priority, and another 30% said it is extremely important. So people are really really focusing on this. But there's a lot of moving parts in an organization. So that's another dynamic that CHROs are making sure that they're part of, as, you know, like IT is doing one thing, operations is doing one thing, and it really needs to be kind of a centrally managed decision. And again, like the why is there, but the how. So it's making sure that HR is aligned with kind of the IT priorities, and then the responsible AI use, of course. So I think that was, you know, my 5 or 10 minutes. I'm a lawyer, so I will talk forever. But I think that it's a good time to pause and pass it to my fellow panelists.
Thank you, Harry. Sarah?
Thanks. Thanks, Valerio, and thanks to Valerio and the organizers for putting this together, and for inviting me also. So, you know, stepping into the shoes of labor adjudicators here, as some of our panelists, thank you, yesterday noted, but there haven't been too many decisions in this area yet. So decisions of arbitrators or labor boards dealing directly with this type of new technology. There have been some, and particularly in their surveillance realm, but not too many yet. So, you know, looking down the ice, so to speak, there are a couple of things that I think are going to be really important and are becoming increasingly important from an adjudicator perspective. And one of the first ones is, you know, what legal paradigm is really going to be most relevant to deciding these kinds of questions. So, you know, the application and adaptation of existing primarily non-labor legal frameworks to these emerging technologies. So, you know, what legal areas or regulatory paradigms are going to be engaged here? Is it going to be, you know, privacy? Is it going to be property-based framework? Is it going to be digital regulation, or some combination of these? And is it going to be, you know, a legislative regulatory regime, most probably mixed in with some common law? So, you know, how are these going to be applied or need to be adapted to address unique features of the workplace context? And this also gives rise to the questions of, you know, how these decisions that are made outside of labor realm, so in courts or through regulation or legislation, you know, constrain or influence labor adjudicators as well. So, you know, this matters because labor adjudicators will inevitably be influenced or constrained or guided by these legal principles being developed elsewhere in non-labor forums. And so this may shape the boundaries of what labor adjudicators can or will do. Secondly, you know, it raises a question of adapting to the labor context. So workers, as they intersect with this technology, are not only the providers of labors, but they can also be the source of data. And this was discussed a little bit yesterday also. And so this raises some foundational questions about, again, the appropriate regulatory approach. And so, you know, how might these choices about how to regulate that strange intersection of what you're getting from workers, not just their labor, but also their data, how might that influence not just rights arbitration, but also interest arbitration, and other labor relations processes? Thirdly, it raises some questions, and sorry to get sort of technical and boring, but these are going to be important questions, I think, of jurisdiction, the jurisdiction of labor adjudicators. So, you know, the Supreme Court of Canada has decided in Weber and Parry Sound that the jurisdiction of arbitrators has been expanded to include things that emanate in their essence from the collective agreement, and including a jurisdiction over interpreting and applying employment-related legislation. So what does that mean when we're dealing with this kind of technology? You know, already these adjudicators have to deal to some degree with privacy legislation, privacy regimes, which are not the natural habitat of labor arbitrators, let me say. But, you know, we're going to start to get into data protection laws and other regulatory regimes. Again, if property and digital regulation become prominent or important here, which they probably will, are those then going to come within the jurisdiction of labor arbitrators? And how well equipped are they to really deal with that? I mean, those questions about how appropriate and how well equipped arbitrators are to deal with human rights legislation and other types of workplace legislation are raised, with some good reason. And as we get further and further from the traditional core of labor and employment law, these become more acute questions. And finally, this also raises questions of disclosure and evidence. So we've talked, disclosure, admissibility, and associated evidentiary issues. So again, this is kind of mundane and boring, but I think is going to be acutely important for arbitration and other labor tribunal decisions. So, last day we heard a lot about the opacity of these technological tools and the inner workings being unknown to even those who are employing these tools, and the role of external and often extra-jurisdictional third parties. So this raises questions about disclosure. The fundamental test for disclosure is care and control. Well, does the employer really have care and control of not just the data, but maybe even the tool itself? Maybe the care and control of this information really is in the hands of external third parties who may be, if not legally, then practically beyond the control of the tribunal. So admissibility and compellability become real questions here. Arbitrators have the discretion to admit or exclude evidence beyond the boundaries of what would ordinarily be admissible or excluded in courts. So what does that mean when we're dealing with this type of data and these types of tools? And finally, expert evidence. What's this going to mean for the process and the cost involved in arbitration? Are we going to really have to see far more use of experts in arbitration? And is that going to be really a fundamental problem for trying to adjudicate this and trying to, for unions at least, to try and protect worker rights? And then the final point or question is, are adjudicators, and for that matter, counsel representatives and the parties themselves, do they sufficiently understand how this technology works to be able to apply the regulation and also, deal with it in an adjudicative forum? So thank you, and I'll pass it on to my co-panelist.
Okay. Well, Henry, after listening to you, now I know why we have a problem, because employers don't really know what they're doing with AI out there. They have their own questions here. And thank God we have Sarah who's going to figure this out.
I don't know if it's fair to say that they don't know what they're doing. But I can understand why you would say that.
Yes. Yeah, because what I think we see across, and just so everybody who isn't a member or a leader in Unifor in this room understands, we are in 24 plus sectors of the economy, and we're dealing with AI and automation in every single one of them in some form or another, because it is the shiny new thing, you see. Just like in the 1990s, the shiny new thing was how do we speed up the assembly line? A lot of this has not changed. It is just that everybody is engaged in it right now. The fear I have about a lot of it is some of it is unnecessary, and we're using a lot of capital to use AI and not actually get something better at the other end of it. And I say that because I'm going to give you a couple examples, because this is the best way to deal with problems, is to have examples around it. If you've ever been in an airport lately, is the AI and the automation that's in that airport making your experience in the airport better or worse? I will tell you, it's likely making it worse. I just flew back from Vancouver this week, and what happened, they had one line with the automated, all of the stuff, that was all the way back. And then the line with the actual people working in the job to check your boarding pass was flying through, because of course the machines break, People who are using it are cranky travelers. They don't quite know what to do. It's 6 o'clock in the morning and no one can figure out where the boarding pass goes. So you get frustration being built up and you get no worker there to help you. And then that becomes the worker's fault because there's nobody there. We have pretty much a situation of newsrooms who are dealing with AI, with ChatGPT, the chat systems, all of that kind of stuff, which is designed to try and replace journalists. But of course, that is not the news we want. We want real news to consume every morning because the world is a mess and we need to know what's going on. And we don't want to read that through, a program. We want real people telling us what's going on in the world. We have a situation in Fort McMurray, as an example, where some of our members drive very big trucks. They're so big that the tire is 5 times taller than me. And currently, the proposal from the employers that we replace the operators of these vehicles because we want them to be autonomous, and that's supposed to save us a ton of money. So that's what's driving a lot of this, but is it actually effective, and does it make jobs better? Are they actually replacing workers, or is the machinery now, you need more workers to be able to maintain those things? So I think all of this comes back to the fact, what it is does a union do in a workplace to change, mitigate, and have an impact around these types of new technologies, whether it's being driven by AI or whether it's automation. All of those things are the same. And I think there's a real danger because the titles are fancy, like algorithm management, that it can be scary for people. But yet it is really the same thing that unions have done around things like health and safety, around how they deal in the workplace. They have to be able to interact. They have to be able to understand these things. They have to be able to use the structure of the union to make sure that this actually is good for the workplace and that it is good for working people. And that's why we need to have democracy at work. And that's why unions have to do that in the workplace, but also in the broader society in terms of how do we answer all those questions that Sarah's just proposed? How do we regulate this stuff? All really, really important. But the reality is nothing changes what the role of the union has to be in the workplace in terms of how we use collective bargaining, how we create committee structures to be able to make sure that we understand what is happening there. And we've been doing it, I mean, in all of these places. I know Tammy is here right now. She's gone to many, she leads our aviation sector in Unifor, and she's gone to many conferences where airports are looking at how they can be more efficient. But the reality is, if you continue to do something like paying baggage handlers $18 an hour, they're not going to show up to work if they can get a better job. And then all of a sudden you can spend as much as you want on AI and on better technology to get the bag down the line. But if there's nobody there to actually do the work, machinery doesn't work, the automation doesn't work. You need people to be able to operate all of that. And what I see right now is a lot of employers investing a lot of money in things that are not necessarily getting the kind of outcomes that we need to get and to improve basically the conditions of work and then the conditions of the world. So yeah, it's a whole thing. In terms of trends, I would say for us right now, big trends are how this gets used to surveil members. To have surveillance in the workplace is a very big problem. If you look at the transport sector, if you look at people who are on camera basically 24 hours a day because they say this is about safety when really it isn't about safety. It's being used to discipline our members all over the place. This is a problem. It's a problem in the rail sector. It's a problem in road transport. I'm sure Len Poirier could give us many examples of how this continues to happen. And so one of the trends is making sure that all of that data that's being collected isn't actually being used to make people's working lives worse. and being used against them. And that continues to be a growing problem. I will add one last thing. This was something that Angelo shared with me because I had to do Angelo's our head of research back here. I had to do an interview yesterday on this very thing with Auto News, who wanted to speak to me about robots in the workplace and robotics and how this was going to replace people. And Angelo reminded me of this very interesting story from the 1950s. And Walter Reuther was a union leader, and he was doing a shop floor visit. And the lore of this story is that he was walking through the assembly line with Henry Ford II. And Henry Ford II was very appreciative of obviously the workers and all of that, so much so that he was pointing out, look at all these great robots, Walter, you know, aren't they great? How are you going to get union dues from these robots? And Walter said, well, Henry, how are you going to get the robots to buy your cars? So yeah, we're not a lot has changed in the world.
Thank you very much for this first round of answers. And my second question has to do with regulation. And yesterday and today we heard about the potential role of regulation and policy in this area, where we see, especially in North America, lawmakers actively restraining from intervening in this field. And there is room for regulation in many for many things, I think, in this field. First of all, there are practices to ban. Emotional surveillance, psychological surveillance must be banned. It cannot have a place in modern society. 30 years ago, we banned polygraphs at the workplace. You cannot use a polygraph at the workplace unless you work with CIA officers. And as far as I know, no one is saying, oh, if only we had allowed polygraphs, we would now have flying cars, right? You can ban certain practices. But there's also room for the absorption of negative externalities, the ones that Simon was talking about. The law is about absorbing negative externalities. Now, negative externalities is just a posh word for free riding. Okay, if I introduce a bot that forces customers, instead of being able to talk with a bank agents, to go through minutes and minutes of interacting with a bot that doesn't work, and only at the end of this very excruciating process I get to talk with someone, and at that point I'm super frustrated and yell at them. This is negative externalities that has passed from the people who implement the bot to society, to the customers and to the workers. The role of the law is also to absorb those negative externalities, because this is a cost that the adoption of technology is basically downloading of society. And in a way, it's a form of freeloading.
Yes.
But the other thing that I think regulation could be useful to is also to allow and foster dialogue between employers and the workforce. Because at the end of the day, and this is something that we were also discussing yesterday, the workers normally are the ones who are actually able to do the job, and are also the ones that are able to tell the employers, look, this new technology is useful or is completely useless and actually is making our life miserable and doesn't help us and doesn't help you. And unless you have something that fosters the dialogue, and in some cases that can be collective bargaining, but we can imagine other forms of if you want, stimulating the kind of dialogue between workers and employers, a lot of negative externalities can also be absorbed through the kind of feedback and dialogue. So I was wondering if you see any role for regulation. What are your thoughts about that?
Yeah, sure. So, you're right, like North America compared to Europe, which has the EU AI Act, which provides some regulations. The US specifically is not in a position where, they can really pass any laws.
Especially anything dealing with tech. No one wants to regulate that.
No, you know, and in the US, you do hear it will restrain, you know, innovation. So I think from the perspective of our members, we talked about two things. We talked about like kind of the emotion reading AI as one thing, and then the negative experience other. I have never heard a single one of our CHROs. Now there are bad actor employers out there. There are. I mean, I could never with a straight face say that there aren't people that do things badly. But none of our CHROs have, most of them have been kind of horrified at the idea that you would be reading a job applicant's facial features and things to understand whether they would be good at the job. They don't believe. So they would probably be okay with being like, you can't use AI to like screen people's facial recognition, their face features, their kind of body language to discern whether or not they would be a good candidate. On the negative experience side with saying, well, we don't want a chat bot, so we should ban those things because it just ends up making somebody angry, and then subsequently that anger gets taken out on society or the eventual worker that is, you know, left to deal with the upset person when they finally press zero enough and get to, or type in, I need a person. I think that there would be much more hesitancy over that simply because the technology is likely so new that there's like, look, this is a developing thing. And if you go and ban that, at this point, you're removing the ability for the technology to get to the point where that wouldn't happen. And I think if we look at history through a lot of processes for the assembly line or even the internet coming around, you'll see that some of those initial problems that are created eventually do like get solved. As far as specific pieces of regulation, my members would want, like would have things, but generally what they want is consistency and expectations. We have a situation in the US where like every administration that comes in, there's a big seesaw with how the regulatory and legal landscape works. And what they want is consistency. So that would probably be the overriding task. They don't want to feel like that they're being limited in the way that they can experiment to use the technology. Like I've never heard of anybody saying they wish they had polygraphs either. So I think the emotional intelligence thing is a pretty safe thing to say that people would be fine with not, you know, being able to do that. Kind of like in Europe, there's the high risk AI platform, like high risk AI that you like can't use. That type of like those categories, I think people could generally agree on. But the key will be that there's like consistency and they understand the frameworks that they're going to be working with or being required to work within.
Thanks. So in terms of regulatory reform and what role there might be, you know, again, stepping into the shoes of the adjudicator from that perspective, you know, law rarely leads it, it usually follows, but I have some optimism that this time lag could be minimized. You know, ideally it would be an anticipatory rather than a reactive approach. And I think that some of Simon Deacon's comments this morning and observations this morning are very helpful in this regard. You know, he said, in essence, AI and technology may be new, but it's not really that new. So, you know, we have frameworks in place, we have regulation in place. It may need to be adapted and reformed to varying degrees to make it appropriate to deal with what is new about this new technology, but we're not starting from zero either. So, you know, what I think, again, from an adjudication perspective is very important here is that with these adaptations of existing frameworks and questions about, again, you know, which paradigms are going to be engaged for regulating these technologies, you know, it's critical that the workplace perspective be fully engaged in these developments and amendments and adaptations, both from the legislative regulatory point of view, but also from the common law decision-making point of view, because again, as I mentioned before, that is going to have implications for adjudication in the workplace context, in workplace tribunals as well. So, as part of this, I think it's really important for everyone, for employers, for unions, for policymakers to think very explicitly about how and where, and by where I mean which forum, these regulations are going to be enforced and interpreted and applied, and what are the implications for the answers to those questions of how and where enforcement and interpretation is going to happen. And I think that needs to be dealt with very proactively, because the implications for all workplace actors are very significant. And there are also, this is a world of limited resources. Employers have limited resources, unions have limited resources. That resource question and the very practical ability to enforce workplace rights, or to gain clarity on workplace rights and how they apply in the context of this new technology, at the end of the day, to some degree, is going to become a resource question. And with the nature of the technology we're dealing with, I think it can be quite acute in certain cases.
Okay, I want to share this optimism that we are actually going to develop a law before we have 15 million collective agreements that have had to address this first. But I have a feeling that we're going to have to rely a little bit on what we can do at the collective bargaining table in order to achieve what eventually will end up in regulation, or eventually be banned because it's a terrible thing to do. And we just have to look at the evolution of things like, how did we get to a place where we had hazardous materials identified in a workplace in terms of from the health and safety perspective? That a lot of that happened through a collective agreement because we had strong health and safety committees in order to make that happen. And then eventually a legislative campaign occurred in order to make this more broadly applied across a sector or across a jurisdiction. And I don't know that we're going to get to a place where we will have this all figured out in terms of how do we regulate it? How do we do all this? There are elements of it that we sure will have to do. But I think this means we have to be more aggressive in what we do in workplaces, because that will augment, I think, where we can get to on the legislative front. And because so much of this technology is also in front-facing services. So, for example, I'll go back to airports again, because I think it's really important. People get really frustrated with using the AI or using the new automated shiny new tool. And so are you all familiar with the Air Canada chatbot court case? Yeah, I mean, this is an example of how people are just not going to put up with bad technology that gives them bad information that then impacts their lives, and they end up having to pay thousands of dollars in plane tickets because the chatbot didn't really have the answers. And so they lost the court case. Air Canada lost this court case because garbage in, garbage out. And that's kind of where we are a little bit with some of the kind of automated tools that are being used right now. And people get frustrated. It's supposed to shorten your time on the phone because you have to go through all of these, for example, automated versions of things before you get to talk to a real person. So people who are using the tools, the public who are using the tools, are extremely frustrated with how this isn't working to their benefit. And so that impacts service. And then that impacts the bottom line of some of these big companies. So eventually they're going to have to figure this stuff out. But until they do, we will have to force them to figure it out at a bargaining table, is what I'm going to say to all of you, and make sure our committees are doing what they need to do in the workplace to control some of this.
Thank you. And actually, if I may, again, abuse my powers as a chair.
You're going to abuse your powers as
exactly,
a chair.
And
Okay.
I am pretty happily doing so. And if I can actually follow up on this question of collective bargaining, which is, I think it's crucial. Collective bargaining is a form of regulation. Actually, it is the closest form of regulation to where the things occur.
Yes.
And but at the same time, we now have an issue with bargaining over things that no one at the bargaining table might have control on, because even the employers who may buy off the shelf systems that they're introducing in their workplaces may not know, may not be able to give the answer on some of the technologies that they are
Correct.
deploying, right? So I would like to ask Henry and Lena to speak from their respective sides on how collective bargaining can actively regulate these things, but how also do you overcome this information, this lack of information from either side? And to Sarah, who is our technical expert, I would also ask, what does the law can do already to, if you want, use some of the instruments that we have to foster a more meaningful dialogue? Yesterday, we were talking about the duty to bargain in good faith. How do you bargain in good faith if no one at the table is able to deliver information on things that affect the bargaining unit? I really want to start.
So collective bargaining from the perspective of the CHRO, the power and ability to use that as a method really depends on where the employment investment is. In the US, I think only 10% of private sector employees are covered by collective bargaining agreements. So in those cases, I know the CHROs where they don't have a CBA, they have a lot of employee engagement to try and get feedback and everything, because again, the CHROs are about talent. But what we talk to the CHROs about is when you go globally, particularly in Europe, there's going to be a need to work with your CBA or your works councils in order to, implement the AI tools. I had one CHRO that was talking about how they were going to do a global rollout. And I was like, well, do you know anything about the Netherlands or Germany, where you just wouldn't be able to do it because you would have to go and negotiate with the works councils? So I think in some industries and in some locations, collective bargaining does create an avenue to have employer and employee dialogue over the use of AI. But I can use an example of the East Coast dock workers and that negotiation, which happened in early 2024 and got completed. Their agreement said there's no AI at all allowed in the ports. Now, the question that I have is, yeah, you know what? I mean, there's a lot of jokes in the US because there's $1 million crane driver, and these people are, the $400,000 longshoremen. These are very high paying jobs, but is it really in the best interest in the long term of the employee to have a CBA that says there's no AI allowed? And I think some reasonable minds could probably say, yes, that may not be great, because it would, in my mind, and this is not, none of our members have said this, but this, in my mind, that's kind of like being like, well, we're not going to use the internet. I had a boss once who said, not a single CHRO opens an email. We will never do that. Well, that obviously changed. So I think that where collective bargaining is applicable, employers are willing to have a talk about the use of AI in those agreements, and it provides an opportunity about it. And none of the employers I know are trying to automate everything and get rid of all the people. But so there has to be kind of a bilateral willingness to discuss what works and what doesn't. And I think the infancy of the technology, although we did hear a lot about how algorithms and things have been around for a long time. Lana's point about garbage in, garbage out is something that our members fret with all the time. That's why they don't use, that's why many of them say we will never use recruiting software to help our DE&I slate, because if you're not putting in a diverse slate to the software, you're just going to get a it only has that to work with. So I think that there's an opportunity, and there's got to be a willingness from each side in CBA situations to say, how are we gonna use this? Because it's like the internet. I don't think it's something that you're just going to be able to say, well, we're not going to do this.
Thank you. May I go to Lana first and then Sarah?
Well, this is why I employ 250 really smart negotiators in the union, so they can figure this stuff out for me. And some of them are in the room, so they're all listening now. But I mean, the reality is it's not just what you can negotiate in the agreement, whether you need to do vague language to make sure you have an opening to be able to address things going forward. What the point is that the dialogue has to continue on. There has to be a way for the union to interact with the employer on an ongoing basis on what is happening in the workplace, and in the case of how automated tools are being used, how the workplace is changing. And so union structures can help that, collective bargaining can help with that. But I would say that this is moving fast. So you may identify and be very specific about things in a collective agreement today, that before you get back to a bargaining table in 3 years, that has completely changed. So we have to obviously make sure we're structuring things to give us an opportunity to be able to go back, have the ongoing dialogue with the employer. It's interesting right now because in so many ways, we have been doing this for 100 years. I get it. You use the one example of where there was a problem and maybe not so much engagement in terms of what had gone on in that port dispute. But if you look at some of our collective agreements that are as thick as this, even in the railway, they have been discussing and putting in language for a very long time how we deal with these kinds of workplace changes. So I think the key here is to make sure that people are not discouraged because they think it's something shiny and new. The dialogue still has to carry on, and we've got to be able to support that as a union and have our great research folks and negotiators to be able to do that and make sure we're providing what they need to do it. I think the other thing which we have to be aware of is how, also from a perspective of what happens with the data that gets collected, I know, and what you can put in collective agreements around that, because you really do have to put barriers around it, and how unjust that aspect of AI and automation can be. Like, there's no equity lens on any of that. And it's a real problem for our workplaces. So how do our committees also engage in that aspect of how this impacts work? We've got a big job ahead of us, but it's not like things we haven't already done.
Can I ask you a question?
Sure. I might not have the answer, but go ahead.
Well, that's okay. I just make everything up, so you're welcome.
Me too. Can't you tell?
Yeah.
Listen, I'm the one that sends the note to the IT person every morning that says my phone isn't working. So I don't know what I'm doing on a panel on AI.
So how do you talk with your members if you have situations where you have unionized companies and non-unionized companies? As we go forward, if there's a perception, whether it's real or not, that the unionized company is not adopting AI or the tools as fast as the non-unionized environment, and the non-unionized, it may be a real, or at least a perception, that it is succeeding more as a company.
I think the job of the employer in that case is to show how the tools can increase productivity in the workplace, and how those productivity gains are going to be delivered to working people through their collective agreement. And if you can't do that, then you got a problem. Like, why are we changing the machinery just because? How are we investing capital-wise in that workplace so that you know, we are getting better outputs, we are getting better outcomes. And if an employer can't respond to that at a bargaining table, then I would say they have a bit of a problem. Why are you doing it then if you're not actually improving the workplace and the bottom line? And if you're improving the bottom line, then we should get a piece of that.
Right, because one of the things that I encounter quite a bit, because I do a lot of work in Europe, are concerns from my European members about global competitiveness and because of the social dialogue, which is the general, I'll use that as my general description of union, CBA, works councils. There's, a perception that because of those requirements, that the competitive landscape is not as advantageous for them compared to US companies that have
a free for all.
Yeah, I always hear is it's not a free for all, but it's at will employment. At will employment. Like the US has that at will employment thing. And I always, somewhat cynically respond that says, yes, but we have a plaintiff's bar. So, which is not the same thing, but like that, hence my cynical joke. But, that is where that this is growing so fast and it's really in its infancy. So from a CBA perspective, I know that my European folks are always concerned about where does the language in the CBA need to be to ensure that for both the company and the employees, 3 years from now, when you're getting to the next CBA negotiation, you've not inadvertently left yourself behind because this is so quickly growing in capability and what it can and can't do.
Yeah, but can't you build that into the ongoing social dialogue?
So you can build it into the ongoing social dialogue, but for me, that's a little that's true. But in the end, you can have actors on both sides, not just the employer or the employer side or the employee side, really stop things by pointing to the CBA or their right in the social dialogue process to demand information and consultation. And it really can only take one member of that, even if you have real uniformity and a great relationship, to really slow that process down. And then, and then there's fear from the firms. I mean, one of the things that the CHROs talk about is there is a fear of falling behind. And I hear it from employees too, when they talk, because it's like this overwhelming thing, AI, sometimes it's even hard to define. But I think in those negotiations, that's a real concern, is that it's moving so fast. And a chatbot now, let me tell you, I have tried the United Airlines chatbot and it gets nowhere. I asked it to recommend flights and it gave me a $2,000 flight to Chicago. And when I just did the search myself, there was one for $188.
So maybe getting employers to slow down on this stuff is really in the end to their benefit, because they're spending a lot of money on bad stuff right now that will need to be upgraded, that will need to be replaced so quickly. So where does it end?
Well, I mean,
hire a few people and let them talk to folks.
Look,
customer service, I think they call it.
Yeah, customer service, employee and customer experience. I think that the fear is that not the fear, but the reality is that the trial and error as you go through this is viewed as necessary to get to the place. I mean, if we think about early internet sites that didn't work, dial-up internet didn't work. And I remember, hearing people being like, well, I just want to be able to go to the store, not have to go to the internet. But that was because the tools were really in their infancy. If you had said slow down, would it have moved at the pace that it did now? I don't know. That's a conversation for a beautiful glass of Cabernet and at night. But I think that would be my
Except
should we
in
slow
this
down?
country, you wouldn't get any U.S. Cabernet.
Well, that's so funny. I was out with a dear friend of mine who's he's a native Ontario guy. And I ordered a Maker's Mark at the bar out of habit, because it was, it's what I drink, because I have celiac and I can't have beer. And the waitress came back to me and she was like, sorry, sir, we don't have any American bourbons. And I started laughing and I was like, yet another reason to change my vote. Or not change my vote, yet another reason to go and vote. Because I got a beautiful Canadian whiskey.
Yeah, there are lots of good ones.
Okay, can we hear from Sarah, please?
Sorry, Sarah.
Right. I'll be much more mundane and no alcohol involved. So Valerio had asked is law in some way being able to foster meaningful dialogue, and gave the suggestion of, or the example of, the duty to bargain in good faith. So so the legal process, both in bargaining and under the labor relations collective bargaining legislation and within the arbitration process, does put some pressure, some very practical pressure on parties, and probably from a realistic perspective, probably that pressure is mostly going to be on employers to produce information. And this is probably going to have some second order effects on creating some dialogue. So if we think about, for example, the duty to bargain in good faith, I think the example that Valerio had yesterday was whether the employer can answer questions, legitimate questions that the other party is entitled to have answered in bargaining. There's another aspect of the duty to bargain in good faith, the obligation to disclose crystallized decisions that'll have effect on the bargaining unit. So replacement, displacement, or significant change to work duties. Yes, this could well be a pressure on employers. The countervailing problem is that what's the consequence for violating the duty to bargain in good faith? I mean, what are the remedies for that? Yeah. Generally considered to be almost wholly inadequate. Typically, it's a declaration, right? So how much pressure is that? It's a question mark. Maybe that needs to change. Boards have broad authority to be very creative with remedies, and maybe more and better remedies are necessary. In the arbitration forum, what we're probably going to be talking about largely is discipline grievances. So if we think about the arbitration process there, the employer has to demonstrate they had just cause for discipline, right? So, what does that mean in terms of information sharing? And again, we'll go back to disclosure obligations and admissibility and evidence. If the party is unable to provide disclosure or to lead evidence, first of all, that might limit what the party can argue. If they can't provide disclosure, might limit their case. If they can't lead, practically speaking, can't lead evidence, that may have significant implications for their ability to justify the discipline. So there might be some practical elements of pressure that are applied to parties. Again, there's a very practical, pragmatic questions, but indeed they may lead to some dialogue out of necessity, as the parties have these disputes and they're faced with some resolution mechanism for them.
Thank you, Sarah. Before opening the floor to Q&A, I just wanted to say something about the European model and what Eric just said. Of course, Eric was just echoing what he heard from his European. But I think that in Europe, at the moment, there's a lot of debate about how much regulation stifles innovation. I'm afraid that thinking that getting rid of that regulation and of social dialogue would bring Europe to the same speed of tech innovation that it exists in the US is just magical thinking. It's something that we hear a lot, but doesn't take into account that one of the main issues why that kind of tech innovation has happened in the US is also because of the military industrial complex. The R&D that has been driven by the US military is something that has not been developed in Europe. And I don't know whether we want to develop that, but certainly this is not because of social dialogue. it is not social dialogue that is hampering the kind of innovation. Europe doesn't have the same venture capital market because Europe doesn't have the dollar, so it cannot leverage against the euro the same kind of financial edge that the venture capitalists in the US can mobilize. So the idea that we can somehow deregulate any kind of markets in Europe, and we will have the Silicon Valley happening in southern France, I'm afraid this is really magical thinking. But that's my
With
just
a
my
few unicorns thrown in.
So let me make
European
of course. Well, so first and foremost, obviously I'm not a European. I want to just make sure that I'm being clear when I say stifle innovation. I wasn't suggesting that if Europe was deregulated that they would have a Silicon Valley. I think when I was talking about innovation, it was the ability of companies to implement some of the tools that are being implemented other places like AI, because like you couldn't do it in Germany because you have to go to there. Now, I have heard when I've been in Brussels and other things, general economic competitiveness. So that was why there were choices to kind of roll back some of the supply chain due diligence rules. But yeah, in no way, shape, or form was I trying to suggest that social dialogue is somehow at the heart of Europe's lack of a Southern France, Silicon Valley, which sounds really lovely, by the way. You should go with that. So yeah, just to make sure that that's clear.
Thank you. I am at the moment wondering why Osgoode doesn't have a campus in southern France, considering the polar vortex.
I think the weather would be nicer than here. Yeah.
Are there any questions from the floor? We would really welcome.
Lord, they're all getting up. We're never getting out of here.
Who gets to go first, the short one or the tall one?
Go for it.
Thank you, appreciate it. Hi, I'm Susan Ursel, I'm a labor lawyer. I am going to do a bit of legal geeking out on arbitral problems. Oh, sorry. Oh, that's where my mouth is? Okay. So I just 2 points. One is a bit of a story and the other is a bit of a question. The first is a case I did years ago for the then CAW at the 407 call center. They had introduced biometric hand scanning, much to the objection of your bargaining unit members there. But 3 bargaining unit members in particular were affected. They were evangelical Christian women with a profound and devout belief in the Book of Revelations. And they identified the biometric hand scanner as an instrument of the beast, because it did an algorithmic scan of their hand, took a number, and the use of the number of the beast to identify humans at the end times is strictly prohibited in their religion. We won that case on the basis of religious accommodation.
Yeah, that sounds like a good one.
And it occurs to me that in the current environment in the United States, religious freedom being touted as it is by that end of the spectrum, that's an interesting monkey wrench to throw into these kinds of algorithmic changes in the workplace. So that's just a tale, and I think it's interesting. But there's another tale from the work that I've done and others, notably Mary Cornish in pay equity.
Yes.
And Mary Cornish brought many cases, continues to be a fighter for pay equity and all things labor rights related. But she brought a case in the 90s, which entailed a criticism of a pay equity gender neutral comparison system that was an off-the-shelf product from then Stevenson Kellogg. And she critiqued that product, and she was promptly sued by the company for the critique that she engaged in the pursuit of a pay equity complaint before that tribunal. And that was a significant impediment to taking forward cases against technology, or in that case, well, we can call it technology. There was a time when we called everything technology that wasn't just what we did. And it was a significant impediment to the prosecution of that case. And this is maybe for Sarah, because I think that what I can foresee over the horizon as a litigator for some years now is exactly that situation. We're up against trillion-dollar platforms and their spin-off companies and their spin-off companies who have significant investments in an off-the-shelf product that they're touting to employers. And in order to unpack the algorithmic decisions that are made, for example, in discipline and discharge cases, you're going to have to look under the hood.
Yeah.
And in order to look under the hood, you're going to have to subpoena those proprietary documents, and you are going to have the fight of your life getting those proprietary documents in order to attack it. Now, I can think of all kinds of collateral ways of dealing with this, which is if we can't get disclosure, then the employer can't prove their case. Bingo, the discipline or the discharge is void ab initio because they are incapable. But I see those kinds of proprietary and technological collision courses on the horizon for us as we use our collective agreements and our arbitration capacity to deal with these problems. And I see it on the regulatory horizon as well, because I'm very, very familiar with and support a multi-pronged approach to regulation of these things. So I wonder if the panel can talk about the collision course of proprietary with collective agreement rights and other rights accorded by legislation.
Thank you. Can we take another couple of questions and then we do the final round?
I'll leave that one to the lawyer and the panel.
Okay. I'll try and be as brief as possible. Christopher Garrett with Unifor in the rail division. One of the companies I work with a little over 5 years ago approached us. They were implementing automated inspection portals. This is an early form of AI that we saw earlier in the week. Machine learning was where it started, and it's been developing ever since. Part of the process in doing that, and the reason I stand up is we're talking about using existing legislation in the context of AI, is that when the company initiated wanting to use this, they had to engage through the health and safety process because it was a new procedure and new tool. And we have been going back and forth for years now, doing risk assessments and responding to applications for exemptions from Transport Canada and such. It slowed down the process, which I think is a good thing, because like any AI, it's very good at certain things, not so good at others. It has difficulty picking up defects in couplers and in wheels, such as that. And as such, we still have our members complementing and doing actual inspections, and they haven't been able to just turn everything over to the AI. I'm curious to hear what the panel's thoughts is on the use of health and safety, our right to participate, our right to know and refuse on AI and how far that goes. Because we've spent years now discussing this. It slowed it down. We've been able to get some information, but not all information from the company, especially on how it works, data storage and all that. So I'm curious to hear the panel's thoughts on how far, at least on the federal level, the health and safety the Canada Labor Code goes and would allow us to get this information out of employers, and what effect that might have on a broader scope.
Thank you very much. And
Hi, John Weir, Cape. Just a quick question for Lana. There was a point you made that really struck me, where you sort of talked. No, in a good way. In a good way. But where you talked about, the amounts of capital that are being invested into this, and something that Henry too said, that part of this is a trial and error. Well, trial and error costs money, and absolutely obscene amounts of money are being put into this. Right? Yesterday, what was it? CPP Investment Board just announced they were putting $500 million into Grok. Yeah. Which is
into Grok?
Yeah, I think so. Yeah, which is screwed in its own kind of way. But I guess I was sort of wondering if you could talk more about this, the amount of capital that's going into this, really for the benefit of a fairly small number of people, and the kinds of maybe foregone capital investments that aren't going to things that would put more people to work or that would benefit, workers more broadly.
Thank you.
I mean, like generally from the employer perspective, and at the CHRO Association, we haven't had a discussion with our CHROs talking about like the investments specifically or where else could be used. But the sense from our survey data is that the investment needs to be there so that you're keeping pace with the you're keeping pace with the market because of where the future state of the company, the industry, and the economy will be. So that's probably my unsatisfactory answer. But those types of discussions we haven't had, and I haven't had a chance to speak to our members about them.
Do you want me to speak to that? Yeah. So I mean, we see it all the time, and I use the airport example as you know, a ton of money, hundreds and hundreds of thousands of millions of dollars being spent to basically replace the lowest paid worker in the airport, and the end result is you're not actually getting a better airport experience. So, you know, is it really driving productivity? I would say to you, it's not. And that is, I think, a fundamental problem that we have, is a lot of money is being spent that isn't actually giving us and not giving workers more wealth. It is basically one big, massive industry right now to sell what you're talking about, these things off the shelf. And they're going around to employers everywhere saying, this is going to make your business better. And because it's AI, everyone believes it. So I got to get the next new shiny thing. And yet it's not really improving much at all. So how do we differentiate between AI and automation that's good and that is augmenting work and that it is actually making work safer potentially, versus the mass amount of what we have going on at the moment? I am a firm believer that there is a lot of overlap between our health and safety rules, regulations, and rights, and what we have in collective agreements in order to tackle some of this, as Chris has pointed out, and we are doing it in lots of places. So some of the language and some of the rights are already there to be able to deal with it. Once you can identify this as a hazard in the workplace, then we have a case to be made.
Sarah?
Susan, thanks for your comment and question. I hadn't been aware of Mary Cornish's experience with that, but can well imagine that scenario arising, and certainly arising again. Yeah, look, this is going to be a big problem, and it's going to cause difficulties for litigation. It's certainly going to, in the, for example, discipline context, going to cause some real difficulties for employers. So, you know, I think you're exactly right, and I mean, we'll see what happens. But as employers seek to use these kinds of tools, if they're going to use them for management and for discipline, you know, then they have to also think down the line of how they're going to deal with challenges to those decisions, and from a very practical perspective of how that's going to play out. And you know, I can foresee, again, looking far down the ice, some real difficulties there, but also making very complicated and therefore really expensive litigation for all the parties, which is going to be something that both sides are going to have to confront.
Thank you. If the panelists agree, can we allow the last two questions? If you can keep it
it's kind
short.
Of hard to say no, I guess.
I have more of a comment than a question. No, I'm kidding. I actually have a question. I'm Mark. I'm a researcher with Unifor. I cover the media sector, among other sectors. I think we're going to be seeing in the near future a lot more coverage about the overwhelming amount of lobbying that takes place by big tech companies in Canada, provincially, federally. I know it because I'm helping work on it a little bit in the background, but I'm wondering, my fear is that regulators, legislators, members of tribunals aren't, like, they haven't necessarily sat through conferences like this. They might not be as up to speed as they could be. And they also, I don't think, have a full grasp of the political moment that we're in. And that's deeply concerning to me. And so I'm wondering what your thoughts are on, you know, the folks that make our laws, including employment and labor laws. What do you think we need to do to make sure that they are both, from an educational perspective, understanding what it is they're passing laws about, and then also how do we get them to grasp the political moment that we're in terms of, you know, big tech, the overwhelming avalanche of lobbying, and right now the deep connection between digital tech platforms that are US based and the US administration right now.
So
Can we hear the
Yeah,
last
that's,
question?
Henry, that'll be great for you to answer that one.
I will, yeah. I thought I made it through the whole section.
No.
Let's hear the last questions and then we have the final round. Janine.
Mine's just a very fact-finding type of questions for Henry. Thank you for the panel. I was wondering amongst your membership, how many are approximately investing in bespoke software for AI and human resource management, and how many are buying off the shelf? And then the use of AI in compensation setting, how common is that? And if you could discuss what you see as some of the risks behind that.
So to your first question, I unfortunately don't have any data from our members on who's using or what percentage of each are using bespoke or in-house AI platforms versus who's buying Workday or Oracle and then tuning them and customizing them for the use of their business case. That's actually a really interesting question that I'm going to go back and see if my team can get some data on. But I do know that when I've sat in conversations, when people are talking about an off-the-shelf product, the focus is always on the kind of like implementation and tuning it to their organization and the challenges that does provide. So I apologize that I'm not able to provide the perfect answer. As far as compensation goes, I think that there's the leading way of using a comp data is still using market data that's available, but eventually you would assume that there's going to be AI solutions. Now that gets into that area where people have expressed a lot of hesitancy among our members of using things that for recruiting slates, for example, or for evaluating candidates in interviews based off of facial feature and recognition. There's still a wide recognition of the need for a human element in evaluating and making those decisions. So it'll be interesting to see if that changes as the tools mature and so on. But right now, comp and recruiting, people still, I mean, I just hear a ton of doubts about the tools. We did the association used to have something called the Recruiting Software Initiative about 6, 7, actually it's more like 10 years ago, where all these recruiting softwares, we would basically evaluate them as vendors, and because our members at the time were getting an onslaught of them. And what the members were telling us was it was really like bad data in, bad data out, and that the tools, they would do exactly what the algorithm said. However, if you didn't have the right thing going in one end, and I think with comp, recruiting, employee performance, it's the same thing. There's still not a belief that there is the right data points going in, so it's still being handled by humans. Should I talk about the lobbying one now?
Why not?
Okay. So I'm not going to even pretend to know that I understand the lobbying context of the Canadian federal government. But in the US, yes, there is a massive amount of lobbying, and how to term it, close relationships between notable people in tech and leadership that may have not existed in other administrations. I think that maybe I could be in politics after giving a response like that.
You just described Inauguration Day.
Yeah, that's great. Yeah. So, it's difficult, and over another glass of Cabernet, I can talk about the U.S. lobbying and the issues with PACs and super PACs and how they've impacted the ability of high net worth individuals and organizations to have an impact on policy and regulatory. In this area specifically, as employers, because obviously we are not at the CHRO Association, one of those multi-billion-dollar PACs that have the ability to spend all this money. What we have found effective is going directly in with our members, not with a political bend, just to say, if you do X, this is what companies will have to do. Now, the other unfortunate thing about the US right now is there's not a lot of policy that's happening in, I guess, the traditional way of the Senate and House start a bill, I can sing that song. So a lot of it is happening through executive orders.
Oh, we know about those in Canada.
Yeah, executive orders. That is a very difficult thing to lobby against. We had a big issue with the H-1B executive order fiasco, where there was a perception by the administration that H-1Bs were taking away American jobs. And we're going to now put a $100,000 price tag on H-1Bs. And you have to go in and be like, and show with data to like kind of dispel as best you can. And honestly, even if you show something very frank in front of, sometimes it still doesn't work in this environment, but you have to like say, these are not taking American jobs. It's the same with the illegal immigration crackdown in the US. The idea that Latino migrants are taking away American jobs is an absolute and utter fabrication. It is. Now, on some occasions, and by the way, this is not anything that any of our members have. We are clearly in Henry's personal perspectives. So this is not something that the CHRO Association or the members have endorsed, but from a lobbying perspective, that's what you have to go and show. Now, early in the kind of the legal immigration crackdown, some CEOs did have success engaging with the federal government by getting personal meetings with Donald Trump and showing them the impact. And they were specifically from food production. And it was like, look, if you do this, like the direct consequence is going to be that people are not going to be able to harvest food. And that got change. So it's a very difficult game right now in Washington to play. It's hard to get hard to get to the right person. It's hard to know how it's going to be received. There's not the normal legislative process. So the best thing you can do is arm yourself with actual data, pragmatic, non-political, consequences of it, and just say, if you do A, B is going to happen, and here's why. Or we use H-1Bs for these roles. You can take a look very clearly that these are not jobs that we're passing up American citizens for. Never mind the economic benefits of having the best and brightest move to the country, which was a foundation of the United States for hundreds of years. But that's what you have to do. And I wish that I had more encouraging words about what's going on in Washington. But it's just the way it is for the time being.
Thank you. Sarah, I don't know if you want to say anything about this.
I don't think I can add to that.
Okay. And then
I have a couple of examples of how we've interfaced with these big tech companies and how they've slowed things down or made things really difficult. And obviously in the media world, you will recall we got a piece of legislation. It took almost 10 years of work for us to do it. It's called the Online News Act. And it was really about trying to protect Canadian news and Canadian journalism. And we had some big opposition there, like Meta, Facebook, Google, they were all trying to slow down this process. So in the end, we got, a decent piece of legislation, but it could have been much stronger. And I think we have to arm ourselves with the understanding that this is going to be an ongoing, very big problem, because tech, unless we get a bubble that's going to burst soon, which likely will happen too on the stock
market.
Hopefully
not. I have 4 kids that are
might slow some things down for them. But the reality is that they now form a massive lobby, and often they work together, which means trillions of dollars worth of capital that we're up against. But there is this other side of things with all of that. most people identify, they don't romanticize big tech in the way that you would think. I think they do see it as a problem. There is a conversation that can be had with the Canadian public about this. I think it's very easy to get the Canadian public on side when it comes to the ethical concerns, the labor concerns, the legislative concerns that we would have. But you have to be committed to this for the long haul. And I will give you one example of that. It's called Uber. We are still fighting Uber from the perspective of the misclassification of workers, from their ability to lobby from municipalities to provincial to federal governments, and how they have held back what we need to see happening in that space of gig workers. We are 20 years in and we're still trying to fight for rights for gig workers. So this is going to be an ongoing problem. And as a movement that represents working people, we have to make sure that we're in it for the long haul here. No sugarcoating it. It's a problem.
Thank you very much. Thanks a lot. And this concludes this final panel. We now move to the concluding remarks, but can I ask for a round of applause to our
Do you want to share? How do you want to do it?
Okay.
If you want to say something, then I will just say aye.
Okay.
We
have a ruckus panel back here.
When I can't answer questions, I use.
Okay, so we know that everybody's kind of on their way out, but I just wanted to do a little bit of a recap of what we tried to do with this conference in terms of the content, if you haven't noticed. So, of course, we started with the impacts of AI on labor markets with a great presentation from Janine. And then we moved on to the kind of an assessment of the state of things around surveillance monitoring. And we did a really good briefing on algorithmic management. And then we got into the responses to AI and did another assessment there. And this morning we went through the history of algorithmic management, and then we just heard from our decision makers. And so that's really, we wanted to create this space where we had people who were coming from different perspectives from different experiences to kind of break down any barrier that there may exist on a conversation around AI. And we also wanted to move beyond the AI good, bad, AI yes, no, like we had to go a little bit deeper. So I think from our perspective, there were a lot of light bulbs that were lit throughout the sessions over the last few days. So we're pretty happy with that. I think that folks who collectively bargain around here have some frameworks to work from, maybe some things to inspire the next few steps or what we're dealing with in the next little while around AI. And we wanted to hopefully create some inspiration for for action, for reflection, and for maybe future opportunities for discussion like this. So I think the ability for us to have in the room some workers, some researchers, some union staff and leadership, lawyers, academics, we have industry reps, all of that really helps to look at the issue from different perspectives. And from my experience, from our perspective, I think things are very successful. And so we want to thank everybody for being here. And I will pass it over to Valerio.
Thank you. Just to say, as a final remarks, thanks a lot, first of all, to all the speakers, especially those who traveled very far to be here. Thanks to all the participants. I think we had really a couple of days of intense dialogue, and I personally have learned so much from this interaction. I just wanted to thank again Osgoode and Osgoode Professional Development for hosting us, Unifor for organizing, and Roxanne in particular for again believing in this project and being pivotal in achieving this successful conference. I just wanted to thank the technical team here at ROPD and our communication workers at Osgoode and the interpreters for their wonderful job these days. Thanks again. It's been a blast. See you all soon.
Stay warm.